Hello everyone, this is Rajiv S. Khanna for Immigration.com, the law offices of Rajiv S. Khanna PC. Um, we have been blessed with the new immigration reform outline. So this is the Senate bill um, that we've got the outline for. I want you to remember this is just a bill. It is not the law yet. A bill will go through many different transformations before it becomes a law. There can be transformations based upon the debate. There is a hearing scheduled on comprehensive immigration reform in the Senate itself. Then there can be the House version. There can be a compromise version. There's many possibilities yet. However, this bill does reflect certain things. It's a mixed bag. Some of these are, in my view, good, and some of these are not well thought out. If you wanted more information on an ongoing basis, just go to immigration.com, and on the very top, you'll see a link to Comprehensive Immigration Bill Reform page. We have these ongoing, several times a day updates to that page. Also, you can follow me on Twitter. My user ID there is immigrationcom, not dot, but just immigrationcom. And you can also download our app for iPhone and iPad. It's a free app. The app is called immigration.com. That said, let's delve into this bill. First thing I wanted to discuss was H1 and L1 visas. And I'm going to separate discussion amongst various visa types and green cards, different recordings. This one is focusing on H1 and L1, and I have a comment about F1 here as well. What are they planning to do to the H1? First of all, the base cap goes up from 65,000 to 110,000, and the exemption for master's degree holders goes from 20,000 to 25,000. So these have to come from STEM. You'll hear the term STEM time and again, and I'm sure most of you are aware that STEM means science, technology, engineering, and mathematics degrees from US schools. Then in future, the H1 cap can go as high as 180,000, but it's tied into a formula which is a composite of, they call it the high skilled job demand index. It's a composite of two variables. One is how much was the shortfall in the H1s for that fiscal year, and also the Bureau of Labor Statistics data on management, professional, and related occupations category. So this is a formula that will take us all the way to 180,000 if necessary, but each year we can go up or down by only 10,000. So it's both up as well as down. Don't get excited. Increase in H1s, what they have given with one hand, they've taken away with another hand. Let me show you what I mean. First of all, there appears to be a predisposition to believe that the H-1B workers are undercutting the wages paid to American workers. So what Congress proposes to do, or Senate proposes to do, is that H-1B employers must pay significantly higher wages for H-1B workers than they do under current law. How they come to that significantly higher wage number is yet to be seen. And a lot of the H-1B workers would not probably have that problem, at least from my experience. Many of them are getting paid way over the prevailing wage. So I'm not sure what the formula here is. It may or may not affect a lot of the H-1B workers or their employers. And then again, it might, depends upon what category of workers we are dealing with. It's also required that every H-1B employer must first advertise the job. And that job must be advertised at the higher wage. So we've got to disclose what we intend to pay. And American workers must be allowed to, of course, apply for that job. The bill further would say that we will provide the spouses of H-1B workers with work authorization only if their country, for example, if they are coming from India, if India gives some kind of a reciprocal treatment to spouses of US workers, then we'll reciprocate by giving H-1B workers' spouses the same benefit. So employment authorization will be given only if your home country where you come from, they call it the sending country, if your country gives the same benefit to spouses of US workers. The third bullet point on this slide I like, a 60-day transition period for H-1B workers to change jobs. What that means is, under the current law, if I'm an H-1B worker and today I lose my job, tomorrow I'm out of status. Okay. Here it appears what they're saying is we'll give you a 60-day grace period to find another job. Okay. This last bullet point is significant in my opinion, and it's kind of stuck into the HL1 discussion, but really is for only students. It says dual intent visas for all students who come here on bachelor's degree programs or above. So remember, this exemption of dual intent visas does not apply to you if you've not come here for a bachelor's degree or above program. What does this mean? It appears to be a small innocuous change, but it's a radical rethinking of student visas. What this means is, remember how you used to go in as a student and your chances depended entirely upon whether or not the interviewing visa officer believes you or not. But with dual intent, what happens is even if you have an immigrant intent, you are allowed to get a student visa. So that would diminish the unfettered discretion, the complete discretion of the visa officer to deny visas just because they don't like something about the student's background or demeanor. So at least from the perspective of, oh, you're going to become a US immigrant, that part would get taken care of. I think it'll make US student visas a lot easier to obtain. So that's a good provision. We like that. Then they have created certain, or they intend to create certain additional burdens on H-1B dependent employers. First part is defining the H-1B employers. And then they have two classes. Those who are 30 to 50% of their workforce is H-1B or L-1B employees, and those that are more than 50% H-1B employees, they have a higher burden. So the idea is, if you are an H-1B dependent employer as defined here, you have 50 or more employees and 30 to 50 of your workforce is H1 or L1 employees. You have to pay, on top of all these thousands of dollars that you pay now to the government, you have to pay an additional 5,000 fees, and this is the H1 filing fees that goes to USCIS. And if you are the more than 50% level, then you have to pay 10,000 fees for each additional worker. Okay. I note one thing for you, that when they do the count of 30 to 50% H-1B workers, they will not count those workers who have a green card petition pending. So if you have, let's say, 100 workers, okay, out of the 100, 70 of them have green cards pending. They will not be counted. So you only have 30 workers. Even if the 100 of them are all H-1B or L-1B holders, you will only be counted as having 30 H-1B or L-1B holders. I'm not sure about the whole math, but this is what they seem to say. Of course, the devil is in the details. When we look at the whole entire bill, we'll be able to give you a better idea. Okay. The last bullet point, in fact, all through this H-1B summary, Congress has used the terms crackdown, as though it almost appears to be, I would say, again, a predisposition that we need to crack down on H-1B and L1 workers. There is also a predisposition or a preconceived notion that all H-1B and L-1 visas are being used to somehow exploit the American workforce. That appears to be a decision already made. So, unfortunately, when a decision has already been made, it becomes very difficult to disabuse somebody of the notion that they've already formed. Whether this is a compromise made within Congress that if you want to get the undocumented workers in the United States green cards, then you've got to throw H-1B and L-1B workers under the train or their employers under the bus. I don't really know what the politics here is, but the bottom line is this is what Congress believes, and this is what they're acting on. Crackdown on the use of the H-1B and L visas to outsource American jobs by prohibiting companies whose U.S. workforce largely consists of foreign guest workers. So what they're going to do is, if a large amount of your workers are H-1B and L visa workers, they will stop you. They will not even issue H-1B or L visas to you beyond a certain point. The next slide will show you that. What they're saying is they have, beginning from fiscal year 2014. When does fiscal year 2014 begin? The government fiscal year begins on October 1st. That means beginning from October 1st, 2014, you'll be banned from bringing in any additional workers if more than 75% of your workforce is H-1B or L-1 employees. Once again, beginning October 1st, 2014. In fiscal year 2015, the workforce cutoff is 65%. In beginning 2016, the ban is down to 50%. So if 50% of your workers are H-1B and L-1, we're not going to give you any more HL visas. Okay. They have, the third bullet point says that the Secretary of Labor has to establish a searchable website, and this website must be operational and online within 90 days of the passing of the new law, and the employer has to have a job open for at least 30 calendar days before hiring an H-1B applicant to fill that position. They also, this is of course already the law. I'm not sure why this needed to be restated, but the fourth bullet point says that we are going to bar employers from recruiting or giving preference to H-1B or OPT workers. This must be a bit of a typo. You can say giving preference, but you can't bar employers from recruiting H-1B or OPT workers. Oh, what they mean is recruiting over American workers. Okay, that makes sense. So the idea is you cannot give preference or discriminate against U.S. workers, but that's already the law. The law is that you cannot discriminate against U.S. workers in recruitment. So I'm not sure. Like I said, I'm not sure maybe they have changed the language or tweaked it somehow to be a little different than the current law. When we see the entire bill, we'll know better. And the last point is that they want to establish significant new penalties. It looks like you're going to see a lot more investigation to prevent, detect, and deter fraud and abuse of the H and L visa programs. Okay, so already the numbers of audits and investigations it has gone up tremendously. I remember in the last, I've been practicing over 2 decades. In last 15 years, we had done maybe 4 or 5 investigations and audits, including Department of Labor, State Department. State Department never did any audits before this. FBI, all kinds of investigations all combined, maybe 5 or 10 in 15 years. Then in last 5 years, we were involved in over 140, 150 investigations and audits. So that should give you some idea of the scale at which the government had already jacked up their efforts. I guess this is the end of our presentation. Once again, I want to remind you, please follow, I'm sure there are other websites doing the same thing. Keep abreast of all the changes that are being planned. It is still not too late to contact your congressman and get organized if you feel something here is manifestly unfair and you would like to take action on it. Thank you for your time, folks. I'll keep you informed of